Hello everyone. In this video, we will discuss about the nitty-gritty of the structural digital database, commonly known as the SDD. This is one of the requirement under the SEBI regulation to maintain this repository while sharing the UPSI with the others. So let's start this topic. So first of all, let's understand like how this SDD came into picture. So when originally uh, SEBI Prohibition of Insider Trading regulation promulgated, it was not there at all in the original piece of the regulation. But subsequently in 2019, this concept of SDD was introduced, and it was like more so with the experiment sort of. That's why the further amendment was made in the year 2020 to clarify certain issue. So let's understand this. What is SDD? So SDD is not S as a legal definition. The SEBI provides the basic framework, or I would say the kind of feature, uh, the certain element of or the software which has certain feature which fulfill to be called as the structural digital database or SDD. So it's like a secure database maintained digitally which contain very specifically these three information, like first of all the nature of UPSI. UPSI mean unpublished price sensitive information, and the name of the person who has shared the UPSI and their PAN. So suppose if I am sharing certain UPSI with you, so my name should be in that particular database with my PAN number. And the third criteria is, or the third information is, names of the person with whom such UPSI was shared. So if I'm sharing that UPSI with you, so your name and the PAN number should be there. The only clarification is there if you are not required to have a PAN. So instead of PAN, there should be some other identifier which may be recognized by the law. So there could be a very normal circumstances wherein the person don't have PAN. So like a foreign national, if you are sharing any information with a person who is not in India or is not required to have a PAN, so you have to obtain the other unique identifier which could be recognized under the law to fulfill this requirement. So it's more about you can understand these features. There is no legal definition per se, but yes, the database should have these information. So if we talk about the feature of SDD, so if you are building that software in-house or if you are procuring any ready-made software in the market from the outside, so that just look at these features. This should be in your SDD. Otherwise, your SDD or the database should not be law compliant. So first is a non-temper. So data could not be tempered in your database. So once you have a system in place, so this is the most important feature. You cannot tamper, you cannot change the data from the backend or something. And to stop this temperability, there is a second feature which is audit trail or the time stamping. So audit trail is whenever you do anything with your software or the database, there is a trail which left behind so that you can do the audit. So that's why we call it as an audit trail. If somebody will check, post the entry, they can check the whole sequence of the event, that how that entry should be recorded, or that time stamping is one of the important feature also, like when you record that information, and the time is very critical. Suppose if I'm sharing that information today and I'm entering that data into the SDD, say after 1 month, so the time stamping will be once I enter that information. So there would be a gap of, I would say, the 1 month very visible, and that should be on the face of the tool itself. The third is, as per the legal requirement, the data has to be preserved for the 8 years, and if and you need to maintain that data for further, and that could be beyond 8 years also if there is some investigation going on and the pending with respect to certain UPSI. So it's not like only up to 8 years. That period could go beyond if there is some investigation pending, and that tool itself internally maintained. So it's not like you can maintain on the some third-party server, which is a fifth point. So that server has to be maintained internally by the company. This is the kind of you can say the feature which your SDT tool must have, or the checklist which you must comply with. Now, if we say which are the entities or on which this SDD is applicable, so this is applicable on the listed entity. So listed entity meaning thereby their securities are listed on the stock exchange. And here the security means does not cover only equity share, it could cover your debentures or other securities also, which are defined in the regulation itself. So all those listed entity by default cover under the compliance or the jurisdictions of this compliance. The second category of the person on whom this SDD is applicable is an intermediary, which which includes your merchant banker, stockbroker. So all those intermediary which are registered with the SEBI, on them also the SDD requirement is there, and it is quite normal and obvious. These intermediaries deals with the listed entity on a very frequent basis. They access to certain UPSI more frequently, so it is an obligation on them also to preserve or to have some data bank wherein they record how internally they are using that information of a listed entity. So again, it is also important on them. The third criteria is the fiduciary. So fiduciary is include the auditor, law firm, and the bankers. Again, these person also deals with the listed entity on a regular basis for various purpose and the work which the listed entity gets. And like auditor is a very legal requirement to get the audit done, which include your secretarial auditor, cost auditor, and statutory auditors. Law firm, bankers, you hired so many people in your daily working. So yes, so SDD tool is applicable on them also, so they need to have uh, the SDD tool at their end also, not only the listed entity. So now, most of the people, raise the concern, or they generally ask why this SDD is required. So SDD help you if suppose there is a leak case, happened in your company. So if you have this database, and as we read what are the information is recorded, you can easily find the linkage, how that UPSI pass through the channels, like how many person involved or how many person having access to that UPSI, so that those record help the company to find or investigate the leak cases. In a similar way, SEBI also when does the investigation. So this database itself, very helpful for the SEBI, and this was the one of the requirement, because in the earlier cases when the SDD was not there, when SEBI asked for the data, there was no reliability, and it was a rabbit hole for the SEBI, to figure out how to get the list of the people who had access that information. And also it is difficult for the company. Like if I would ask you, what how many people were involved in a transaction which happened the 4 years back in your company, so you cannot recall. You will start looking at the mails, chat box, messages, and it's so difficult. And the data is also not reliable, because it's humanly not possible to remember those information. So that's why this database helps the SEBI to conclude matter much faster, and SEBI can figure out what are those person who have the UPSI, and can take action against them if they traded in the securities of the listed entity while having the UPSI. So it serves the both sides, regulator also, and the listed entity as well. So now, if I would say you have a system, everything in place, whose responsibility is this? So law, or I would say regulation, provides the onus on the board of directors. So how they say, like, board of director needs to ensure, it's not like they will do the entry of or the record the transaction in the tool, but the board of director has to ensure that there is a system in place which is recording the UPSI sharing, name of the person who is sharing, and the name of the person with whom is sharing. So it's more focused on to maintain the system. It's not about the board of director will do this entry. Ultimately, the person who is sharing have to record that, and how the company is making those compliances. This also depend how many people can access this tool uh, to for the control purpose. So now it's the most important part. I think whatever we have read, it's more about features and seems to be a kind of the recording task. But the most critical part is how to identify what is UPSI. Only then these tasks will be triggered to record the transaction or to record that entry. And the UPSI itself is a very subjective definition which is given in the PIT regulation itself, but how they define and being the subjective criteria, so they give you two principle, like any information which is not publicly available and likely to affect the price. So you have to read these two statements simultaneously. It's not like or. Both conditions should be satisfied, then only you can say that particular information is a UPSI. Being very subjective criteria, given in the regulation, that's why there is an illustration provided in the regulation itself, or I would say the deeming provision or the deeming fiction, that these items by default are the UPSI or considered to be UPSI, which are like financial results, dividends, change in the capital structure, merger, demerger, acquisition, delisting, disposal, and expansion of business, and change in KMP. And these items can be further, bifurcated into the small pieces as well. It's like financial result. When I say, it's not only the draft financial statement form, it could be one particular component as well, like sales figure, any expense figure, your profit number. So financial result is a very broader term. What comprised of or how this financial result arrived at, you also need to consider those factors as well. In a similar way, like change in the capital structure, so how your capital is being changed, what is the the presentability also include, like even the split cover under the change in the capital structure. So this is how, is being the subjective definition, these are the criteria which you have to be considered while deciding the UPSI. Apart from it, like as you can see on the screen, there is a extract which I put in the slides. Like even the regulator sometimes very much grapple with the issue, like what is a price sensitive information, and this has to be decided on a case to case basis. If those or any information falling under these criteria, there is no doubt, and it's like a thumb rule, you can consider this information as a UPSI. But if anything apart from these five element is there, it's very subjective criteria and not so clear to define as a UPSI. So just for clarification purpose or for the illustration purpose, I just picked one case wherein there is a kind of clarity, we can say, uh, on the fact of how to determine the UPSI. So it was a case, company named Shobha Limited. It's it's a public domain. You can check the details of the cases. So this company is in the real estate business, and they generally disclose their real estate updates to the stock exchange. So on a one particular day, which is the 6th October 2017, they disclosed the updates on the real estate business to the BSE and NSE post market hours, and that that update includes the sale number. And Mr. Bala Murugan, the name is there, who is a person who collected that information from the different department right from the 1st of October. So the number was pertain to 30th September, which was, like I would say, the quarterly not published result, but it is a information as on 30th September 2017, and he started collecting that information right from the 1st October. So you can say the germination of that information start from 1st October. And before publishing that data was vetted by Mr. Jagdish, who was then the chairman and the MD, who also bought the share on the 6th of October. Now, the most interesting part is, first of all, should this sale number can be construed as a UPSI or not? And that's the whole questions in this case, because that person was charged uh, with the non-compliance of, or I would say, the trading in the on the basis of the UPSI. So the only number which is visible there is a sales number, which SEBI picked during the investigation. And how they interpret this sales number, I just uh, use the extract of this order. So if you see, like, most of the people so far before the judgment considered that one particular line item cannot be construed as a UPSI, but they said that your sale performance for the particular quarter, if materially affect the price of the security, that can be construed as a UPSI also. And in the second extract, wherein the officer said that it is not necessary per se that particular information affects the price, or there would be a movement in the price, even if they have a potential to affect the price of the security, it is enough for them. So this is how they interpret this UPSI stuff. So now the most important part is when we can share the UPSI. So in general, you are not allowed to share, or you're not allowed to communicate the UPSI, but there are certain exceptions. And if you are sharing any information for the legitimate purpose, or what could be the legitimate purpose, like in your ordinary course of business you share the information, and it's an obligation on you also to share that information. That's the first criteria, you can share that UPSI. But again, when you are sharing, you have to make an entry, as we uh, gone through previous slides. And second is that if it is a performance of part of the performance of duty or the discharge of the legal obligation, then again you can share your UPSI by doing the necessary compliances. The three things which you should consider while sharing the UPSI is, first of all, which the PIT regulation itself provides, that the execution of the confidentiality agreement should be there, and you should intimate the other party about the confidential nature. So it could be, if you are sharing the information through the mail, you can have a small paragraph that this information which I am sharing with you is a price sensitive, and the confidential nature, you have to maintain the confidentiality. So again, the third point is about the due notice to maintain the confidentiality. So these three things should be kept in mind while sharing or before sharing the UPSI. So these checks should be there, so that and accordingly you can also need to make entry. So sharing is a one piece of the compliance, and the second piece is to record in a proper way in the tool. So suppose while making an entry, if you do some wrong entry, so as I said, because the tool itself, or the feature of the tool, is like you cannot tamper the data. So if you made an entry which is the wrong one, simply you can make another entry by giving reference to the previous one, and there is no need to delete, because there is, I should say, there would be no case or such scenario, because you cannot change what has been entered in the tool. So even if it is a test entry, even if it is a wrong entry, or some information is not correct, you should not touch, or you should not touch that entry or the tool from the backend. Simply make a fresh entry by giving reference to the previous one. That is the proper way of making the compliance. So now let's pick few of the FAQs through which we can understand this topic much more. And so generally people ask, when the UPSI is germinated. So you can consider these three pointers when you should consider UPSI, because it's very important to make an entry perspective. So once you decide this is a UPSI, you have to make an entry. So again, you understand at which point of time that information becomes the UPSI. So the point number one is when information start taking shape of the price sensitive information. The second one is the probability of going ahead with the information is higher than. So if you are ready to take the next step on the basis of that information. And the third one is it has a potential to materially affect the price. So if these three criteria are matched, then you can say to some extent that yes, it is a particular information which you have been discussing for a month. It's an UPSI, and the moment you decide that information is a UPSI, you have to make an entry before sharing that UPSI. So the second FAQ is like, is it necessary to enter the details in the SDD if it is shared internally with multiple times in a day? So again, just to clarify, there is no distinguish between internally and externally. Even if you are sharing within the organization, you have to make an entry. And again, if you are making an or sharing that information with outsider, you have to make. So there is no doubt about, if you are sharing internally, so you are not required to make an entry, you have to make an entry. So now the question is multiple times in a day with the same person or sort of. So the 3 pointers which I made, like the entries need to be made the person wise. So if I'm sharing with the 10 different people, I have to make an entry with the 10 different people. So it's not like I'm sharing instantly, so that 10 entry should be there. If I'm sharing with A, so Rohit is sharing information with A is a one entry, it should be recorded in the tool. Rohit is sharing within the same day with B, so Rohit to B linkage should be there in the tool itself. So the entry is made person specific, not the information is specific. It might possible in a single day the same information shared with 100 people, there has to be 100 records in your tool. And the second is, so if the UPSI is shared with different person in a day, then for each person the new entry, as I clarified. And now the question is, if the different part of the particular UPSI are shared multiple times in a day with the same person, then the single entry can be done. So suppose if there are different parts of a one particular UPSI I am sharing with you, like suppose 20 times in a day, so one entry would be sufficient to make a compliance that yes, on particular day Rohit has shared the information with Mr. B. 20 times is not necessary, even a one single entry would be sufficient compliance. And again, like when you say I shared the UPSI, so generally we share the such information on emails. So and on emails we shared maybe Excel, maybe some PDF documents or the Word document which have that unpublished price sensitive information. So is it mandatory to upload that document? So if you read the law, if you read the particular regulation, it does not prescribe as such to upload any documents. They just simply say the nature of the UPSI should be captured, not the document per se. So you can avoid that part. So if you are like mentioning that nature of the UPSI in a very clear way, so I don't think there is any requirement to upload the document or that information in complete way. So these are the few FAQs and some pointers which I made to clarify this topic. I hope you like this video, and thank you so much for your valuable time. And if you have any question related to SDD compliances, you can ask in the comment box so that I can reply. See you in the next video. Thanks once again.